Certainly, Mr. Locust. Mr. Locust?
Good morning, Your Honors. My name is George Rockus, and with me is Kara Thorbaltson, and we represent the appellant Gregory Aceto. Your Honor, this case involves interpretation and application of the so-called anti-SLAPP statute. My client was the moving party down below. He lost, and as a result, he appealed. My argument today is really going to take you through the steps of the so-called Duracraft test and to demonstrate before this court that the lower court misapplied that test. And before I get to that, I just want to state that, the case law is pretty clear that when reviewing the denial of a motion to dismiss under the SLAPP statute, this court has to look for an abuse of discretion or an error of law, and I submit to the court that in this case there was both an abuse of discretion because the court misapplied the facts, the clear and unequivocal facts, and number two, there were errors of law. I want to start first with prong one of the Duracraft test, which basically says that the moving party has to establish that the underlying petitioning, that the claim at issue that's brought by the plaintiff is based solely on petitioning activity. And here you have to realize in analyzing whether Mr. Aceto met that burden, you have to realize there were 3 counts in the complaint brought against Mr. Aceto: an abuse of process claim, a malicious prosecution claim, and a Chapter 93A claim. The lower court did find that the burden was met with respect to the abuse of process claim and the malicious prosecution claim. In other words, the court found that those claims were based solely on the underlying criminal activity, which I assume Your Honors know was based on the criminal complaint that Mr. Aceto brought against Mr. Wenger. It held, however, that the Chapter 93A claim was not based solely on petitioning activity, and I suggest to you that that was an abuse of discretion for the court to hold that.
But
And
Mr.
why do I
Rockus-
say that? I'm not,
Yeah.
I don't ask you to take my word for it.
No, go ahead.
I
Go ahead.
ask you to take the word of Mr. Wenger. Mr. Wenger and Mr. Wenger's former attorney. If you look to page 12 of the record appendix, it's the introduction to the amended complaint. And I'll just read it. Now comes the plaintiff, Harold Wenger, and brings this action for damages against the defendant, Gregory J. Aceto, arising out of a criminal claim brought in the Dedham District Court, in which a finding of no probable cause was made by the clerk magistrate as well as the court in review of the clerk magistrate's findings. That's what the introduction says. There's no carve-out for the 93A claim. There's no caveat for the 93A
Yes, but
claim.
then the facts, no, you go ahead.
You were going to make the same point I was. Go ahead.
The facts that follow that and that become the basis of the 93, the allegations that are, the facts that are alleged beyond that introductory paragraph and that then get repeated when the amended complaint has the 93A claim added to it, include a good number that precede this application for the criminal complaint and relate to prior conduct. So,
Well, I agree with what you said, but the question is that was the 93A claim based on petitioning activity, or stated another way, if the petitioning activity never occurred, would those 93A claims have ever been brought? And I submit that the introduction to the amended complaint
but that isn't
indicates-
stated the other way.
but
That's a different issue.
Well, I think they're related issues. This says what the entire complaint was based on. If you read it at its face value, it says what it says.
I have a basic question. Can you have larceny of services?
Yeah, well, you're getting to the application of the statute, and can you have larceny of services? That's a good question. Well,
That's why I asked.
I don't
course you
see why
can.
not you can't have larceny of services.
Couldn't you?
Pardon?
Why couldn't you?
I just said, I don't see why you can't. Why couldn't you? She said, could you have?
Yeah.
And I said, I don't see why you could not have larceny for services. And I think you're getting to the application of,
Does it come within the statute?
I think it does, and I know that the argument is, well, one of the arguments that's made by Mr. Wenger's counsel is whether there was an intent to defraud, and there is the.
Well, I don't understand this distinction about no intent to defraud, because once you get over that you can have a larceny of services, I'm not sure I understand the distinction that I think the trial judge made, the motion judge, between larceny of past services and future services. I'm not sure I understand that distinction.
And I agree. I think the court was wrong. I think that even if the check was given for an antecedent debt, there still can be an intent to defraud, because if I tender a check to Your Honor, I think it's safe to assume that Your Honor is going to rely on that check, deposit it into her account, maybe buy things.
But where's the larceny in that case?
Well, the larceny.
There's nothing given in exchange for it. All you're
Well-
doing is applying a check to an outstanding debt.
And the answer to that question, Your Honor, is I think you may be looking at larceny in the traditional sense. I'm looking at the way, I'm reading the plain language of the statute. That's what I'm looking at. And the statute doesn't define larceny in that way. And I think
I take it you're relying on the fact that the bank dishonored the check and said insufficient funds, because that endorsement under the statute says that act by the bank constitutes prima facie evidence of knowledge and the intent to defraud under the statute.
yes,
And with that endorsement from the bank, you went to the clerk's office and applied for a criminal complaint.
that's correct. And so,
If you can have attempted larceny of past services, then that's what he was seeking the complaint for. If you can have that, then the judge is wrong, and the whole case goes away. Am I right? You win.
well, not.
You don't want to
well,
win?
I would agree with you, but I would like to agree with you, but I can't, because I think under the prong to a Duracraft, I mean, it is whether the movement can show whether the underlying criminal petition was devoid of any factual support or any arguable basis in the law, and I think your argument goes to the language after the or.
Well, no, because what I'm postulating is that there is a reasonable basis in the law.
Well, there is.
Yeah.
But
You may not win.
But the whole case
That's
wouldn't go
correct.
away, though, because you would still, I mean, quite apart from that, you do have count 3.
Well, in count 3, I suggest.
Well, I know you do, but, I mean, it's a
okay.
different argument.
Yeah.
Well, 2 of the counts would go away.
Two of the counts go away, and let me suggest, so I don't forget, that Mr. Wenger argues on appeal, he challenges the finding that the abuse of process and malicious prosecution claim don't go away. He challenges the fact that those claims were not based solely on petitioning activity, and that issue was never appealed from. So I would argue that issue is waived by Mr. Wenger. But I would agree with you that if we win, we should win. We should win it all. And I suggest to you, getting back to the 93A claim, I do think you have to take Mr. Wenger for his word. What was the 93A claim based on? I didn't write the complaint.
But there's a difference between the motivating factor for bringing the case and whether the basis of a particular claim is solely the petitioning activity. In other
That's
words,
true.
you may be right that had your client not sought the criminal complaint, Dr. Wenger wouldn't have bothered. But I don't think that necessarily means that the 93A claim, if it is in fact alleged to be based on antecedent conduct, would necessarily fall.
Well, and that's where you have to parse what this introduction means. And I agree with Your Honor that intent is not a factor. But I think that this introductory paragraph meets the Duracraft test in favor of my client. And again, I didn't write the complaint. It says what it says.
Could I ask you one question back to application? And I appreciate your argument about the meaning of Section 37, but what do you say to the point, I think, that Dr. Wenger makes? Well, if larceny, which seems to be defined in the section, that if you actually get money or property, that would be larceny as opposed to attempted larceny. If larceny under that statute means that you get the property, then attempted larceny under that statute must mean that you tried to get the property. So it wouldn't be going to an antecedent debt.
Right.
That's the argument. So I wonder what your response is to that.
My response is that the statute says nothing about attempting to get property or getting property. It just doesn't say that.
Well, it does talk about getting property because the last line says, if you, I've got to get
No,
it.
what if it says, the only time it says it is if money or property or services are obtained, they shall be guilty of larceny.
Right.
But there's nothing about trying to attempt property in the first
But
part
what I'm
of
saying
that
is
sentence.
if you read that sentence as meaning that would be larceny, that you actually did obtain money or services,
Right, I agree with that.
then logic might say that an attempt to do that would be the first part of the statute.
But
Attempted larceny would be trying to get that.
It doesn't say that, and I would say logic would tell me that the legislature wants to actually prevent situations like this from people passing bad checks. So if you look at if you look at some sort of public purpose, it's a rational public purpose for the interpretation that Mr. Aceto espouses to be adopted by this court. I mean, again, you don't want people passing bad checks.
Does the record indicate that at the time this check was presented towards the outstanding debt, that there was an ongoing attorney-client relationship?
Yes, there was. It didn't exist.
Well, it was in the process of breaking down.
Had he retained new counsel?
He retained counsel when the letters were written in the letters saying, please pay me in February '06. I think the record contains a letter by Mr. Franchek, predecessor counsel, on behalf of Mr. Wenger. There was first the check. The original check was delivered in October. Then the check bounced. The substitute check was given in January. I think it was '04. And then in '05, Mr. Aceto wrote Mr. Wenger, and then there was a letter in response, I believe, to Mr. Aceto's letter from Mr. Franchek.
But at that point in time, had Dr. Wenger started going to another lawyer for legal business?
That I am.
It's not in the record.
Yeah, it's not in the record.
Was there an expectation that there would be an ongoing relationship between Wenger and Aceto?
No, because by February, Mr. Wenger was accusing Mr. Aceto of committing malpractice with regard to the case that was tried in which there was a $750,000 verdict against Mr. Wenger. So I don't put it this way. I think it would be unreasonable at that point in time for Mr. Wenger to have assumed that Mr. Aceto was his lawyer.
Do you want to address the attorney's fees point?
Yes, I do, because I think actually that is a very critical issue, whether the attorney's fees that are incurred with respect to defending the underlying petitioning activity are recoverable, in whether that satisfies the second part of the second prong of the Duracraft test. And I would submit to your honors that it should not satisfy the second prong, because if it did, I would submit in virtually every case there would be no need even to look at the second prong of the Duracraft test. Why would you even need that prong in the statute? Because virtually every time, if there's not going to be attorney's fees regarding the underlying petitioning activity, there are going to be least costs and expenses. And I suggest that the statute, the courts, the legislature had to have meant something different than attorney's fees.
Mr. Bacchus, if we agree with you, at least with respect to counts 1 and 2, does this fees issue go out the window?
I don't quite, it doesn't go out the window, well,
It becomes maybe damages for the 93A action.
that's correct. It would become potential damages to the 93A claim. And let me just get back to the 93A claim ever so briefly, because I also submit, in addition to relying on this complaint, that the court should take note that in the record, there is no verified complaint. There is no affidavit from, for example, a legal malpractice expert, in effect supporting these allegations.
But that may go to a whole bunch of other issues with respect to the validity of the 93A complaint, but it doesn't go to this issue. It doesn't go to whether it's solely based on petitioning activities.
Well, I think a court has to look at the entire record. What evidence is there that this is based solely on petitioning activity? And if it wasn't based solely on petitioning activity, and there was a good faith basis to believe those allegations were in fact true, one would think that you'd either have some sort of verified document by a legal malpractice expert, or at least some sort of verification in the complaint of at least some of the allegations that are made. But there's nothing like that. There's nothing like that. And I submit that this is a pure retaliatory claim, and you should take the introduction for what it's worth.
Thank you, Mr. Foy. Thank you, Mr. Locus.
Thank you.
Mr. Foy?
Thank you, Your Honors. May it please the Court, Edward Foy for Dr. Harold Wenger.
If we're discussing so much whether there can be a larceny for past services, how can you say there was no reasonable basis in law for the claim?
I don't believe, Your Honor, that there are any cases which hold that there can be a larceny by check for past services.
Are there any cases that hold you can't
The other
have it?
way.
I don't think there are, Your Honor.
So doesn't that mean it's an open question, and there is a reasonable basis in
Well,
law?
I think that is not the case, Your Honor, simply because under the Massachusetts statute, the crime itself is larceny. The check is the modality and the means for it, but the crime is larceny. The cases that Mr. Rocca cited in his brief all involve statutes where the passing of the bad check itself is the activity that the legislature criminalizes. In this instance, what the legislature has criminalized is the act of larceny, and that means obtaining something of value. What we have here was...
Well, getting rid of a debt, isn't that obtaining something of value? I mean, if you have a debt, you want to get rid of it.
But the debt is not gotten rid of, Your Honor, by a bad check. If
He
one...
attempted.
Neither is the check gotten rid of if,
Doesn't the statute provide, though, that apart from the crime of larceny, that if a bank endorses on a check or bounces a check, if it dishonors the check, that act of dishonor alone constitutes, he may not win the case, but it constitutes prima facie evidence of knowledge of insufficient funds and intent to defraud. And those are elements of attempted larceny. Doesn't the statute say that?
But I think it does say that, Your Honor. But I
So,
think
so isn't there, because we don't have a case on this that really clears this up once and for all, isn't that at least a legitimate basis for bringing or seeking an application for a criminal complaint?
I think not, Your Honor, for two reasons. And the first is that what we have here is that under the language of the statute and the idea of obtaining some sort of a quid pro quo on the particular facts of this case, what we have is someone who, the original 2004 check that Dr. Wenger drew to Mr. Aceto, and which Mr. Aceto put in his briefcase and had stolen, and then Dr. Wenger replaced that with another check. So what we have here is a check tendered in replacement of a check which was tendered in return for services rendered in 2003 or 2004, 2 years prior to the statute. So on the particular facts of this case, any sort of prima facie effect that the statute would give to a presumption that he has taken something isn't present because manifestly he has taken nothing. What
But
he
that's
has-
not what the statute says. The statute says if a person does certain things, he shall be guilty of attempted or of
Right.
attempted larceny. But then it goes on to talk about the endorsement from the bank. And why doesn't that constitute attempted larceny?
Well, because I think, Your Honor, the key phrase here is whoever, with intent to defraud,
And that's satisfied by the bank's endorsement.
makes, draws, utters, or otherwise. But I think, Your Honor, the intent to defraud is not simply satisfied by the bank's endorsement.
But that's what the statute says. It is.
The way I would read that statute, Your Honor, is that there must be an intent to defraud, and that while there is prima facie evidence to be found in the bank dishonoring it, that nevertheless the key issue is whether there is an intent to defraud. And on the particular facts of this case, that intent cannot be found.
Well,
I
you're cutting it too close, it seems to me. Let's begin with the proposition that, put aside a little bit of what happened here, but if somebody painted my house, a painter, and he says, well, you got to pay me for the paint up front, so I pay him $300-400 for the paint, and then he paints the house and he presents his bill for $5,000, and I give him a bad check. That's clearly attempted larceny, is it not? I'm attempting to get his services for having paid, or labor for having painted my house with a bad check.
If Your Honor had intent at the time that you gave him the bad check, or if you
Well,
knew that the
isn't the
check was
intent
bad,
inferable?
if the-
Could not a magistrate issue a complaint on the basis that, okay, we'll leave it up to the judge, the trier of fact, to decide if the intent of the defendant was to not pay for those services?
Let me, Your Honor, there was a case called Commonwealth v. Morton, which actually fairly closely mirrors the scenario that you just gave me, where somebody accepted payment of goods, they agreed to pay for the goods within a week when the goods were resold, and the individual did not pay in the weeks following, and in fact eventually went bankruptcy and relinquished the debt. And the appeals court found that on those facts, a directed finding of not guilty would be required on a larceny charge because there was no proof of intent at the time the services were received not to pay for them.
Well, that may be. That was after a trial, however. We're talking here a clerk magistrate deciding whether there's probable cause, not proof beyond a reasonable doubt, to justify the charge.
Well, that's another point, I think, Your Honor, that should be emphasized here, which is that we do have the decision of the clerk magistrate that this was not a meritorious complaint. And we have that based in part, I think, upon Mr. Aceto's own testimony, that at the time this complaint went forward, there was a dispute between himself and Dr. Wenger regarding the quality of the legal services, whether Dr. Wenger would pay the bills.
Oh, sure, yeah,
Dr.
but I
Wenger-
don't think you can find the magistrate went into that detail. They do this every day. They get in and hold these informal hearings. They say, well, here we got a doctor, here we got a lawyer. This is really something that should be handled civilly. That doesn't mean that they could not have issued a complaint
Well, but
under the
also,
law.
but also in this case, you had the letter that your client had obtained the day before that says this was all a mistake by the bank. I mean, so it isn't, I mean, it's really looking at other evidence. So when you read Magistrate Paterno's conclusion, it's hard to separate out that letter, that evidence.
But I think, Your Honor, the other thing that is missing from the equation is the fact that when Mr. Aceto swore out this criminal complaint, he was acting in violation of substantive law. Chapter 93A forbids the use of criminal process to collect a civil debt. That is precisely what we have here. The case on point in that regard is Weiler v. Bonnell Motors. It's in the 35 Mass App Court volume. And we also have the additional fact that Mr. Aceto was acting, Judge Fabricant, I think, clearly believed, and so do I, in violation of ethical norms by trying to swear out a criminal complaint against a client where there was a known controversy over the payment of these bills.
But Mr. Ford, the basis of her decision that this was had no basis was on her interpretation of Section 37. Don't you
That's
agree?
correct, Your Honor. But I would point out, and this would be also in response to Mr. Rockes's waiver argument, that this court can uphold the finding of the court below on any grounds that are supported by the record.
But it's not so much the findings of the magistrate. It's what was used to go into the petitioning process itself. Was that so totally devoid of any law or fact? And it seems to me that's what we have to look at, not what the clerk magistrate did.
Well, I think if Your Honor looks at what Mr. Aceto said before, it's on page 89 of the record, where he essentially stands up before the clerk magistrate and gives his version of what took place. And if you look at the demand letter he wrote prior to filing the criminal action, he says nothing about you took services from me, you obtained services from me, or anything of that sort. He simply relies on the fact that you paid for this, I lost the check, you replaced the check, the replacement check bounced, and now you won't give me the money. There is not a hint anywhere that Mr. Aceto, at least until Judge Fabricant brought the issue up to him at the hearing, ever considered for a moment the fact that he needed to prove that something of value had been obtained, or that he did in fact try to prove that. It simply isn't there.
But that isn't what the statute says. The statute says that with intent to defraud and certain other things, if you do, you will be guilty of attempted larceny, and then it goes on to say, and if money or property or services are obtained thereby, you will be guilty of larceny. I don't think, was the application for the criminal complaint one for attempted larceny or for larceny?
It was for larceny, Your Honor.
It was for both,
for both?
wasn't it?
Larceny.
The complaint itself is in the record, and I
Mr. Foy, at what stage did Mr. Aceto learn that the bank had made the mistake?
Your Honor, I think throughout the proceedings, I do not know the answer to that question. I didn't represent Mr. Aceto. I think it was sometime considerably after the commencement of the proceedings. I believe that everyone assumed throughout the matter that despite Dr. Wenger's letter, about which so much has been made, everyone assumed that this was an NSF check going in. Mr. Aceto assumed it was an NSF check going in. The magistrate appeared to assume that, and certainly I've assumed that in my brief because it's a favorable fact for Dr. Wenger. If it's one thing, I think, to deliberately stop payment on a check, it's another thing to have a check simply returned for lack of funds. That in itself is not necessarily evidence of criminal intent, even under the statute. The statute says there must be a non-replacement of the check as well. And what we have here, of course, is there was a non-replacement for very good reason. Namely, there was a dispute at that point over whether Mr. Aceto was entitled to the check. And even Mr. Aceto acknowledges that dispute in his testimony before the magistrate. And, as I said before, we also have the additional fact that what we have here is the SLAPP statute being used to, in effect, sanitize or immunize an attorney for actions which would otherwise be a violation of law. The argument being that the legislature in Chapter 93A, on the one hand, forbade Mr. Aceto from doing this sort of thing, using criminal process to collect a civil debt. And yet, on the other hand, through the anti-SLAPP statute is saying, well, that's all right, you can do it as long as it's petitioning activity. There's another case I don't want to, there are two other points I do want to make, so I'd like to move on from that if I can. One of them is that in a recent case called Fisher v. Lint, the appeals court effectively held, following this court's decision in Coulter v. Wood, that participation in what amounted to a criminal proceeding as a witness. In the Fisher v. Lint case, there was a state trooper who complained about one of his colleagues. It resulted in a disciplinary proceeding for the colleague. The complaining trooper was later sued over his participation in it, and he attempted to invoke the anti-SLAPP statute. And what the appeals court said about that was the anti-SLAPP statute simply does not apply here because it is not your petitioning activity to the trooper, even though the trooper himself had been the original complainant, because what we had here was, in effect, a criminal case. A criminal case is not petitioning activity by Mr. Aceto. It is an attempt to get the government to act or to not act. I would also point out, I think we discussed the case of...
But
Did
that's
you
a
make that
petition.
argument below? Did you make that
No,
argument?
no, Fisher v. Lint hadn't come out
Oh,
at that
okay.
time, Your Honor. I would also point out that there was Judge Greenberg's, we also have the issue here of whether Judge
Can I just go
Fabricant...
back, Mr. Foy, to that the whole point of petitioning activity is to get the government to do something. Maybe you're trying to get the government to do something that you shouldn't be entitled to get the government to do, such as the fact that 93A makes it abundantly clear that you can't use a criminal process for that. But that's essentially what you're doing. You're trying to get the government not to issue an environmental permit. You're trying to get the government to issue an environmental permit. Those are the classics, right?
I think that the Fisher case stands for somewhat different proposition, at least in connection with the interpretation of the precise language of the anti-SLAPP
Boy,
statute.
is this the first time you've talked about Fisher?
It is, Your Honor.
Okay, it's not in...
It came down, I think, a week before I filed the brief. The brief was filed on June 28th, and Fisher came down on June 19th.
Do you have the site?
I
Well, you
do,
can
Your
give it-
Honor.
you can send it in.
It's in the 69 Mass App Court volume, I believe.
Okay, that's fine.
Can I
And-
just
and
ask
the-
you, just to get back to this other point, you say it's a violation of 93A to use the criminal process to collect a civil debt. What's the source of that? Is that an AG regulation?
No, the source of that, Your Honor, is a case called Weiler v. Bonnell Motors, one of Judge Cass's decision in which he announces that rule in just so many terms, in just so many words. He doesn't announce it. He actually bases it on several other cases and articulates it. I think there is also, the other point I would like to make is that...
But he's not using the process to collect the civil debt. The check was issued by Dr. Wenger. They dispute what it was for. Aceto says it was partial payment. Wenger says it was total payment. So Aceto is just using the process to validate the check, which Wenger himself agrees was at least in some payment for the services.
I'm not sure that using the process to validate the debt, as Your Honor put it, is what Mr. Aceto had in mind. He wanted his $10,000.
Well, of course he did, yes.
And in order to get his $10,000, he walked into the court and he swore out a criminal complaint against his own client.
He's using it to collect a civil debt. He's using it to collect a payment that Dr. Wenger agreed was owed on the debt.
Which Dr. Wenger at one time had, certainly at one time he had provided him with the check. There's no question about that. But
Yeah.
Dr. Wenger, because of subsequent events, came under the belief that it was not owed. The third point I would like to make, even
Mr.
though the
Foy,
red light is flashing, is that when Judge Fabricant made the decision that Chapter 93A had a sufficient independent basis, the inquiry should have ended there. She should not have separately dismissed the other two counts. The language of the anti-SLAPP statute is, once it has been established that the complaint as a whole has a substantial basis
The
other
cases-
than and in
The cases
addition
you
to.
cite, though, really are, it was one of a piece, wasn't it?
That is precisely, though, the point that's being, that was made here in the complaint. Mr. Rackus read the introduction. By the way, I didn't write that complaint either, and that introduction is a survival from the original complaint that was filed. But if you look at if you look at paragraph 22, what this sets forth is that Mr. Aceto, in substance, failed to committed all sorts of malpractice, failed to call witnesses, failure to research and analyze issues, failed to provide bills to Dr. Wenger, had a dispute with Dr. Wenger over the bills. When the dispute came to a head and Dr. Wenger refused to pay him, Mr. Aceto filed criminal charges against his own client. This was
Mr. Foy, thank you.
all of a piece,
But you really are running out
all of a
time.
piece.
Thank you, Mr.
Thank you.
Foy.